Hello again, I'm Kirsten. I'm the Community Relations Associate at Culver House, Ravenna. Before we start today's presentation, I would like to share a little bit about our beautiful community. Culver House, Ravenna is set in the heart of Ravenna. Residents enjoy the charming neighborhood's tree-lined streets and the lovely shops and cafes. Warmth and energy set the tone at Culver House, where staff and residents feel like family. Life here is all about enjoying comfort and peace of mind in a quaint, well-established Seattle. If you are interested in learning more about our community, please contact our community relations team. We'd be happy to answer any questions for you. And we can be reached at 206-523-7315. Also, I wanted to mention some exciting news regarding reimagining Culver House, Ravenna. Our building was first built in 1949, and many of us know and love the charm of an older building with a legacy in the neighborhood. There are also a number of challenges associated with an aging building, and some of these challenges have become more profound as a result of the pandemic. We are exploring a range of possibilities to reimagine Culver House, Ravenna, so that we can continue to be a place where we can serve seniors for decades to come. Pending approvals, which we expect would occur by early 2023, we hope to begin a redevelopment project. And again, you can contact me anytime and we can talk about any questions you may have regarding this. So now let's go to our main event. And we are honored to host Elizabeth Jennings presenting on the power of planning. Elizabeth is an associate attorney at Northwest Elder Law Group. She received a bachelor's degree magna cum laude from Clemson University and her law degree from Boston College. Elizabeth's practice areas include estate planning, probate, and guardianship. So welcome, Elizabeth.
Thank you. Thanks for having me, and thanks for everyone who is joining today. I'm glad you're here. Today I'm going to talk about the power of planning. And so whether you are just now thinking about some planning, or maybe you've done some estate planning in the past and you are just trying to kind of check in and make sure that you're on the right track, I hope you can take some good information from the presentation today. I could talk about this stuff for hours and hours, but you probably don't want to sit here for hours and hours. So just know we are kind of dusting the surface. But if you do have additional questions, again, feel free to add them to the chat. I'll also have some time at the end to answer questions. And then you're always welcome to reach out to me. My contact information is here. You can find us at Northwest Elder Law Group. So when I am talking to people about planning and estate planning, I usually think about that in kind of two scenarios. Not the most uplifting of scenarios to think about, but still very, very important. So the first is planning for death, right? If you want to pass on your assets to your loved ones, to organizations that you care about, we talk about how we plan to do that and do that in a way that is easiest on our loved ones when we're gone. But then also the flip side is planning for periods where you're alive, but maybe not able to handle things on your own. How do you put a plan in place so that your wishes are carried out and hopefully reduce conflict among family members? That's kind of what we'll be talking about today. So I'll be talking about the estate planning as far as transferring assets, as well as planning for periods of incapacity, and talk about powers of attorney and advance directives for healthcare. So the big topic that people think about when it comes to estate planning is planning for death and wills and trusts, and kind of how we put our affairs in order for when we're gone. So estate planning is kind of this broad term that applies to how are you going to pass on your wealth? How are you going to provide for people that you care about during life, charities, even kind of maintaining control when you're not here, to provide support for the people or things that you cared for during your life. So one big thing to think about is everything you own can be split into two big categories. One is considered non-probate assets. So non-probate assets are things that you own that will pass automatically at the time of your passing. So often these are assets where you have a designated pay on death beneficiary. Those types of assets are not included in your probate estate. They're not necessarily covered by your will. So that's the whole second category, are those assets that are covered by your will or your estate plan. Those are your probate assets. So good first step in planning is to think about financial accounts, real estate, things that you own, kind of which category do they fit into. So most of you probably have some degree of non-probate assets. It could be joint ownership with rights of survivorship. Maybe when you opened your bank account, however long ago that was, you may have designated a pay on death beneficiary. There's some ways to transfer real estate through beneficiary designation. Maybe your retirement accounts, when you set those up, you designated a beneficiary. So all these things are examples of non-probate assets that you can designate today, and pretty simply how you want them to pass at your death. So that's kind of the first to-do list recommendation I would put out there, is think about your financial accounts, whether it's checking or savings or an IRA or brokerage account. Do you have a designated beneficiary on those? Do you have a contingent beneficiary on those? Maybe you've named your spouse as the primary, but have you named a backup? So this is a good opportunity to take a look at all of your financial accounts you may own, confirm whether you've got a beneficiary on those accounts, and make sure that it's who you want it to be. This is a task that you can usually do kind of from the comfort of your own home. If you have online access to your accounts, you can usually review and update beneficiary designations that way. Your financial institution can mail or email you a beneficiary form to update. And it's kind of a nice task that you can do. You don't need the witnesses and the notaries that are usually required for some of the other estate planning that we're doing. So especially if it's been a while since you opened out an account, good time to double check if you have a beneficiary designated on those accounts. Another helpful tool as far as planning to pass on your assets or your wealth, if you are a married individual, you may want to think about a community property agreement. Or maybe you have one that you did many, many years ago, or you've done recently. Good opportunity to kind of think through, is this a good fit for my estate planning right now? So a community property agreement is an estate planning tool that spouses can use. And even though Washington is a community property state, we still distinguish between community property and separate property. So separate property may be gifts you've received, inheritances you've received previous. It could be things that you held on to prior to your marriage. So a community property agreement is a pretty simple document that simplifies the process of making sure that your spouse receives all of your assets if you were to pass away before them. It's essentially like a little contract between spouses that says everything I own at the time of my death, whether it was separate or community, I want it considered community property, and I want it to go to my spouse. So it's a really helpful tool to alleviate the need for probate or a lot of estate administration if you're married and one spouse passes away before the other. It's not always a perfect fit for everyone. It may not be a good fit if One spouse may need to qualify for Medicaid down the road, or if you have a very large taxable estate, it may not be the best fit, but it's something to think about. If you've done your estate planning and you're part of a couple, kind of pull out the documents that you've done and see if you have a community property agreement in there. For everyone, whether you're married or not, probably the most common planning tool or estate planning document is a last will and testament. And so anyone, any legal adult can make or change a will. And at its very basic form, a will is just explaining to your loved ones, to kind of to the world at large, what you want to happen with your assets at the time of passing. And you can gift specific items, you can give kind of everything. As far as formalities, it does have to be in writing. It has to be signed by the testator, so that's the person making the will. And your signature needs to be witnessed by 2 witnesses, ideally disinterested witnesses. So not people that you're actually gifting to, could be neighbors, could be friends, kind of have a will signing party, but making sure that you make your will, that you have it witnessed, and ideally that will is what we call self-proving. That it has a sworn affidavit by your witnesses about the circumstances of signing your will, so that if your will ever has to be admitted to probate, we don't have to go track down the witnesses and have them provide testimony, kind of swearing that they saw you sign the will. So those are the basic will requirements. Again, if you've done estate planning previously, good time to pull out a will if you've done one before, kind of make sure it hits the main formalities. I've had some clients that did their wills 50 years ago, and it didn't quite follow all the formalities. And so it's a good time to get those updated so that there's no issue. As far as the substance of your will, this is where you get to do whatever you want. This is where you get to express your wishes. And I will tell you that most estate planning attorneys, most good estate planning attorneys will tell you kind of, if you can dream it, we can put it into practice. So at the most basic level, your will is at least going to identify who you are and your immediate family. Even if you don't intend to give to any family members, it can be helpful to identify your immediate family. You can dispose of your personal property. So you can gift specific items. If there is that prized family heirloom you want to give to someone, you can specify that in your will. But Washington is also great because we allow testators to keep a separate list. So by statute, if your will references that you may have a separate list gifting tangible personal property, then essentially that list gets incorporated into your will. So it's something you can handwrite, you can type up, you can add to and change as many times as you want without having to update your will. So my grandmother, she did the good old Post-it note method of certain items going to certain people. This is a little bit more formal and legally enforceable if you really want to make sure that there are particular items you want to pass to particular people in your life. You can also specify specific bequests, which are gifts of certain things or certain dollar amounts to people, to charities, to groups of people. Again, kind of what your wishes are, we can usually put into practice. And then there's usually going to be a residuary clause or a remainder provision that kind of everything else that's left after the final bills are paid, after property is distributed, the specific gifts are distributed. If there's something left, who do you want it to go to? Is it everything to one person? Is it divided equally amongst a group of people, different percentages? Again, we can usually make whatever you want happen so that your wishes are accurately kind of detailed in your will. Your will also include designation of a personal representative, sometimes called an executor. That's the person in charge of carrying out your wishes as outlined in your will. So this is one of the big decisions when I'm working with clients as far as estate planning. Who do you trust to carry on your wishes once you're gone? Who is organized? Who is willing to take on that job? Because it can be a job, can be a big undertaking. So it's important, especially if you've done estate planning, if you've done a will before, pull that out, double check who you've listed as your personal representative or your executor. Is that person still involved in your life? Are they still able and potentially willing to take on that role? And have you named some backups in your will? So important to kind of list one or more backups just in case your first listed executor is unable to act. So big thing, double check. You also want to make sure that your will gives your personal representative what are called non-intervention powers. That means that they're able to settle your estate without having to go back to court over and over again to kind of get permission to sell assets, to pay bills. A non-intervention probate tends to be a lot more efficient, a lot quicker, a lot cheaper. So that special non-intervention language and waiving of bond, that can be really important to make sure that your will contains. Your will also needs to be signed by you. It does need to be dated. And your witnesses should, again, sign the will and sign an affidavit attesting to the will, that they saw you sign it. You didn't seem to be under any duress. You were competent at the time. All of these kind of formalities help make sure that you're the person signing the will and it accurately reflects your wishes. Your will may also contain things like a testamentary trust or several testamentary trusts. So a trust can be important if you want to give to someone, give to a beneficiary, but maybe they're a minor, maybe they are receiving needs-based government benefits. Maybe you don't necessarily think they're going to do well managing a gift of your estate. So a trust is a way to kind of hold on to the assets that you're gifting to someone and set parameters for how that beneficiary can use them. So trust can be a helpful tool. They may not be a perfect fit for everyone, but trusts are definitely something I recommend talking with an estate planning attorney about to make sure that it's something that would fit for you if that's of interest. So that's because there are so many different kinds of trusts out there. I always get clients that say, do I need a revocable living trust? I know Susie Orman is a big fan of them. So definitely if you have some property in California, they may be a good fit, but trust may not always be a good fit for everyone. So something to look at your current estate planning documents or talk to an estate planning attorney about. Do I have a trust? Do I need a trust? What are some of the benefits? But a trust is just an arrangement where you are gifting assets to someone, but someone else is managing those assets for them. So kind of the basic trust structure is you would be the settlor or the grantor. You give to someone, but it's held in trust. And you designate a trustee, a trusted person, to manage that property for the benefit of a beneficiary. So this can be helpful if you want to give to like a minor, maybe you have a child or grandchild or great grandchild that is very young. Maybe you put a gift to them in a trust so that it can be held on to, used for that child's or grandchild's benefit. And maybe they don't get a lump sum, at age 18, maybe it's kind of spread out a little bit. So trust can be very beneficial to protect assets from, minors or maybe irresponsible beneficiaries. Maybe you want to gift to someone who's receiving Medicaid or other needs-based benefits. Or maybe you're just a very private person. A will that gets probated is public. It's filed with the court. It's part of the public record. And so a lot of times, a lot of famous people, celebrities, they will not have a will. They may have a trust because they don't want their business kind of part of the public record. Sometimes trusts are really helpful if you own real estate in several different states, so that probate isn't necessary from one state to the other. Sometimes you can set up a trust with some tax benefits. So trust can be really complex. It's worth talking to an estate planning attorney if you think that a trust may be necessary for how you want to provide for your loved ones. So I always get a question as well about estate planning as it relates to taxes. You've worked hard, you want to make sure that your estate goes to the people and organizations that you care about. You may not want that to go to the government, to each their own. So one thing to keep in mind is right now under current law, there is a fairly high exemption threshold, which means that you can give, your estate can be distributed to your loved ones and no estate taxes are going to be due except for over a certain threshold. So in Washington, you can gift up to $2.193 million without any estate taxes being due on your estate. At the federal level, right now, you can gift up to $11.7 million without any federal estate taxes being due. You also are exempt from estate taxes when you make gifts to your spouse or to charities or political organizations. Kind of all of those are exempt. So it's something to talk to an estate planning attorney about, talk to your accountant. If you do have a sizable estate and you want to minimize estate taxes, there may be a way to structure your estate to do so. So I just want to keep that in mind. The other plan is just spend it all, have a wonderful time in retirement. And as my husband always says, I hope the last check bounces. So there's no taxes to worry about, nothing to fight over. So before I jump in to planning for incapacity or disability, I didn't see any questions in the chat, but let me just double check. Okay, I'm not seeing any questions, but I will have time at the end as well. So we just talked about planning for death and transferring our assets. But what I think is even more important is planning for periods of incapacity or disability. So largely that means making sure you have powers of attorney in place. Some people have a joint power of attorney that deals with both financial and healthcare decisions. Sometimes you have separate powers of attorney, one just dealing with finances and property and one dealing with healthcare decisions. But it's important because a power of attorney operates while you are alive, right? So it operates in periods where you may not be able to manage things on your own. So your will only has effect once you're deceased. A power of attorney has legal effect while you're alive. So this can be helpful if you are temporarily or permanently incapacitated in some way. It can also apply if you're just unavailable. I had a client at the beginning of COVID was stuck overseas in the middle of the sale of his house, and he had a power of attorney that allowed his spouse to sign all of the real estate documents for him. So it can be helpful for periods where you may not be able to make your own decisions, or you may not be able to really manage your own affairs or pay your bills due to some sort of cognitive issue. So powers of attorney, super helpful to have, but also a big decision when it comes to planning. Because a power of attorney is a legal document that creates what's called an agency relationship. You, as the principal, are designating someone to be your agent or your attorney in fact. They essentially get to stand in your shoes and act in most, if not all, of the ways that you could act if you were making decisions for yourself. You can have a very, very broad power of attorney, which may be appropriate if you're designating your spouse. Hopefully you trust them. You can also have a very limited power of attorney, designating maybe a friend or a family member for a limited purpose or limited duration. Washington has a pretty robust power of attorney statute. If you ever want to go look at our power of attorney statute, it's within the Revised Code of Washington, Title 11, Chapter 125. And that will detail all of the default powers that can be included in a power of attorney, as well as some of the optional or extra powers you can grant someone. So if you're looking for something to do, a little bit of light reading, it doesn't hurt to look up that statute and start reading through some of the powers. One of the biggest decisions when putting together a power of attorney is deciding who will be your agent, who is your attorney in fact. And essentially you have to ask yourself, who do I trust to step into my shoes? Who do I trust to carry out my wishes and make decisions in my best interests? That could be a family member. It could be children. It can be a spouse. It can be a friend. It can be a neighbor. Or if there's not a friend or family member that you necessarily want to name, you can also name a professional. There are professional fiduciary companies or organizations that this is what they do. They will help with bill paying, they'll help with arranging care. You can designate a professional. They do charge a fee most of the time, but it's a good option or potentially a good backup if you don't have friends or family member, maybe that live close to you, or you don't want to ask them to serve in that role. So something to look into. I also recommend when you're putting together a power of attorney to think about alternates. I was just doing an estate plan for a couple and we looked at the power of attorney they did about a decade ago, and they only named each other. They didn't have any backups. And that can be problematic because if your first listed agent is unable, unwilling, can't be located, then if you become incapacitated, the only real option is for the court to impose a guardianship over you, to appoint someone else to make decisions on your behalf. So I don't know about you, but I would rather pick who gets to make decisions for me than have a court or people who don't really know a lot about me make that decision instead. So again, if you've done estate planning before, kind of pull out that power of attorney, see if you're comfortable with the list of agents that are listed. Maybe you need to add to that or change some people around if they're no longer familiar with your life or they live far away. It can be helpful to have someone local. You also want to consider whether your power of attorney should be effective immediately or it should be effective only upon your disability or incapacity. So an immediate power of attorney is one that your agent can act as soon as it's signed. So they can act concurrently with you. That was the scenario where I mentioned where the individual is stuck overseas. His wife had immediate authority under a power of attorney to act on his behalf. But some people feel more comfortable only having their power of attorney effective when they are incapacitated, meaning that maybe a doctor, their primary care physician, has issued an opinion that you're unable to manage your own affairs. then that will trigger your agent having authority. So also helpful if you've done power of attorney planning before, kind of look for that paragraph about effectiveness. Is this effective now, or is it only effective upon incapacity? And what's necessary to prove incapacity? So helpful to think about kind of who do you want to name in this role, and when do you want them to have authority to act? In Washington, a power of attorney does need to be in writing. That certainly helps. But a power of attorney can either be notarized or witnessed by two individuals. I do recommend that your power of attorney be notarized, especially if it needs to be used for any sort of real estate transaction. Most title companies are going to want to see that that power of attorney has been notarized, not just witnesses. So keep that in mind. It's not something you can just print off the internet and sign yourself. It does have some of these formal execution requirements. As I mentioned, our state statute provides for kind of default powers in a power of attorney, but there are extra powers you can also grant. Do you want your agent to be able to make gifts out of your assets? So maybe you have a pattern of gifting to charities or gifting to family members on an annual basis. Do you want your agent to be able to maintain that pattern? Do you want your agent to be able to change the beneficiaries on accounts? Maybe if you haven't named a beneficiary, do you want your agent to have the authority to kind of fill that in for you if there's a period where you're unable to do it yourself? So a lot of kind of powers you can give someone. A financial power of attorney gives your agent the ability to manage your finances, pay your bills, write checks on your account, pay medical bills. So it's a pretty, heavy duty authority you can give someone. So that's where I would say really think about who is willing to take on that job if needed, and who you're most comfortable with having that authority. It can be a lot. You may also have a separate power of attorney for healthcare decisions. So this is really important if there's a period where you're unable to give informed consent for medical treatment, whether that's temporary or permanent. Who do you want to be able to make decisions on your behalf? Washington does have kind of a default statute about who has authority to make decisions. It's largely like your family tree, right? First looking to your spouse. If you don't have a spouse, your adult children, are they all going to agree? Maybe siblings. We kind of go out the family tree to see who do we find who is able to give informed consent. If you don't like the default rules, if you don't want, your siblings, or you don't trust kind of whoever it is in your family tree to make those decisions, that's where having a power of attorney for healthcare can be really important. You get to choose who has the authority. It's one of those documents that I recommend, if you've done it in the past, pull it out and make sure that your doctor has a copy. It's something to bring to your next doctor's appointment, have it added to your medical file, so that if there ever is an issue, that your care providers know who they can turn to get informed consent. If you're about to do a new power of attorney for healthcare, again, get an extra copy, provide it to your primary care physician. Oftentimes, if you do have to go in for surgery, they may ask you, do you have a power of attorney? Provide a copy or sign our kind of short form. So this is your to-do. If you don't have any powers of attorney in place, now is a really good time to start thinking about that, start planning, just in case, a little bit of an insurance policy. If you do have powers of attorney that you put in place, whether it was recently or a long time ago, now is a good time to pull those out. Look at who you've designated as your agents. make sure you're still comfortable with those people, see that you have any age or backup agents named, and when is that power of attorney going to be effective? Do you want to change that at all? Kind of last but not least, when it comes to planning, are healthcare directives, advanced directives, living will. They kind of come in different shapes and forms. But an advanced directive or healthcare directive is a way you put on paper what your wishes are in certain medical scenarios. So it could be your wishes as far as medical care in an emergency. If EMTs are called to your house, what kind of interventions do you want them to try? Or for periods where maybe you have a heart attack, do you want CPR? Are you in a coma? Do you want kind of assisted medical interventions like artificial respiration, artificial nutrition? So they come in a lot of different shapes or forms. We have kind of a default healthcare directive that you can complete. You can find in our state statutes, the Revised Code of Washington, Title 70, Chapter 122, Section 030, provides some kind of basic choices you can make about periods of kind of a terminal illness, or if you are in an irreversible coma, do you want certain interventions to help prolong your life? You may also have conversations with your doctor about completing a POLST, a physician's orders on life-saving treatment. So you often see those, they're usually bright green. You may have one kind of posted on your fridge or by your front door. But again, if emergency personnel are called, what kind of attempts to revive you do you want them to take? So this is really important to not only share with care providers, emergency personnel, but also your healthcare agent, your family members. What are your decisions for end of life? It can really remove some of the emotional burden on them to make these decisions if they know that they're just carrying out the wishes that you put on paper. So it really is a gift you can give to your loved ones of do some of the hard thinking and planning now, put those wishes on paper, and again, share it with your healthcare providers, share it with your loved ones so they know pretty clearly what your wishes are. So good time, good to-do list to take a mental check. Do I have a living will or an advanced directive? Again, maybe if you went in for a medical procedure, whether that was a year ago, 5 years ago, your care provider may have had you complete one. See if that's part of your medical records. Does it still accurately reflect your wishes? If not, it's a good time to update that. And then also to have those conversations with your loved ones. Do they know your wishes? Is this something that they're going to be able to honor? Some people may not, right? So I think having those conversations early really avoids any sort of conflict, disagreement down the road. So I've told you a lot of things that you should have in kind of your planning tool belt, but just to review some things that you can do now to hopefully make planning a little bit easier, make things easier on your loved ones. If there is an emergency, if something does happen to you, really have these conversations. I know it's a little bit harder these days when we are not in person as much, but having these conversations with your siblings, your children, your loved ones, your trusted friends, letting them know what your wishes are, letting them know what your priorities are, so that your documents, your estate planning wishes make more sense, and they know that they're just helping carry out your wishes. It's also very helpful for your loved ones, for your financial power of attorney, or for the executor of your estate to know what assets you have out there. So helpful, I would say every couple of years, kind of jot down a list of your resources. Where do you bank? Where do you have different accounts? Double check, do you have beneficiaries on those? That can be a helpful list to include with your will or your estate planning documents. Make it a little bit easier on your executor or your power of attorney. If they do need to kind of pick up and handle things for you, they know where to look. If you've done power or planning before, now is a really good time to dig those documents out. Do you know where your original will is? Do you know where your powers of attorney are? And do they still make sense for you in your life? I usually tell clients, every few years or anytime there's a big life event, whether it's a marriage, a divorce, a retirement, a move to somewhere new, that's a good time to pull out the documents and make sure that they still reflect your wishes. So now's a good time to kind of track those down. If you already have documents, see if there needs to be any updates. Along those lines, make sure that your documents are accessible if needed. Do your loved ones, do your fiduciaries or your executor, your power of attorney, do they know where to go find those documents if something happens to you? You don't have to give them copies. That's totally up to you, but you should at least let them know where to find the originals or who to contact. Because all this planning doesn't mean anything if no one can find the documents. So important to know where they are and share that information with your trusted fiduciaries. And then if you are looking to update or put estate planning in place, there's a lot you can do on your own, but it also helps to consult with some experts. So talk with an elder law or an estate planning attorney. Talk with your financial advisors or your accountant. Kind of oftentimes we're looking at the big picture of your assets, your needs, your wishes, and putting a comprehensive plan together. So hopefully this will help, you think about what's important to you, what changes or updates you may want to make, and then be able to come to those experts with some good questions, some ideas, some thoughts about what you may want to put in place. So lots of stuff to absorb, I know. If I'm just telling you what you already know, great, you're in a great spot. You've done planning. If a lot of this was new, there's a little bit more research you may want to do. But I'm happy to take any questions now, but you can also jot down my contact information if you ever want to give me a call or shoot me an email with questions you may have. It's a quiet group, but I will take it.
Well, it looks like at this point in time, there is not any questions that I see. So since we don't have any more questions, thank you so much, Elizabeth. That was very, very incredibly informative presentation today. So we really appreciate it.
No questions.
No question.
What do you
Oh,
think?
do I hear a question? Does someone have a question in the background? Okay, maybe not, but feel free to message me if needed. And yeah, happy to help. And thank you so much for Ida Culver for letting me come speak to you all.
Thank you very much. So again, we'll be emailing everyone an evaluation form and would love to hear feedback like we do after all of our webinars. And again, my name is Kirsten, Community Relations Associate here at Ida Culver House, Ravenna. I hope you have a wonderful afternoon and an excellent evening. And thank you so much for joining us.